The Youth Opportunities Act is, what it will do is for up to 15,000 young people, it will regularly and automatically seal their juvenile records. Washington is one of the minority of states that keeps juvenile records open forever, thus ensuring that youth will have a difficult time getting jobs and housing and pursuing their education, just solely because they made a mistake as a juvenile. It could be a small mistake, and that record is going to haunt them potentially forever. We've seen studies that the existence of open juvenile records falls hardest on poor kids, and it falls hardest on kids of color. So what the Youth Opportunities Act really represents is a opportunity, a second chance for young people to get jobs, to get an education, to get housing, because it doesn't help anyone if we design a system that basically creates an underclass of young people who can't get jobs and can't get housing. We're basically shooting ourselves in the foot by ensuring that those youth are going to end up being poor, being involved in the criminal justice system as adults, or being homeless. And that's a value that I don't think anybody shares. So we've worked for over a decade on making it easier for young people to move past a juvenile offender record. 10 years ago, we put together the first bill that allowed young people to really seal their records on a much quicker timeline. Once they had shown that they had paid their debt to society, that they had moved past their mistakes. So we've been working since then over the last decade to try and make it so that it was easier for juveniles to move past their records. So this year, in this legislative session, we took the lead on lobbying on the Youth Opportunities Act, creating a coalition of people from judges to the faith community to advocacy groups for communities of color, to homeless youth shelter providers, to get them to speak with one voice saying that youth shouldn't have a life sentence of an open juvenile record just because they made a mistake, and we should be able to move past it. So we worked during the session and before the session to come up with a strategy that ultimately was successful, to come up with a compromise that will allow most juveniles to move past those records. The Youth Opportunities Act was, for me, even after 14 years, representative of an unprecedented coalition, a coalition that I think was very firm that they could not stand seeing generation after generation of young people, especially people of color, being discarded into the adult criminal justice system, into homelessness, solely because they had a juvenile record. This is a system that they wouldn't be pushed into had they come from California or another state that doesn't open juvenile records. So there were a lot of people who worked on this. The University of Washington Legislative Advocacy Clinic worked on it. Others, Team Child, who had been working on it for years. And our job coming in prior to this session was to get everybody together, make sure that the right voices were heard in the right venues. So, for example, we worked with Faith Action Network, which has a lot of clergy, and their voices carry a lot further in some areas than the voices of, for example, homeless youth providers, and vice versa. So our job was to figure out whose voice could be most effective with what legislator and with other decision makers as well. This was a tricky situation as well because one of our biggest opponents was the newspapers. And so we struggled because one of our greatest advocacy tools was dead set against this happening. They're feeling that if you close off records, it will hurt their ability to keep the courts honest. So we had to keep that in mind and work around that, which was difficult. But I think it was a challenge to keep everybody together because one of the things about legislative advocacy is you have to make compromises, and compromises are hard to swallow. We started with a very powerful piece of legislation, and we had to make compromises and weigh the needs of the 15,000 juveniles who would go through the system this year and the next year and the next year, and figure out, what are we going to get for the kids this year, and what are we going to work on in the future. And so one of the approaches we used was to keep people very well informed, to let them know that they were an important piece of this, to not sell them short in terms of their investment, to communicate very openly and fully with them about what happened that day in the legislature, what was the next step, how could they get involved. And we had a listserv of over 150 stakeholders, from your neighbor who just cares about this issue because it's an issue of social justice, to the head of the Office of African American, the African American Commissioner, and it was important, again, to communicate both to the group and to individuals and say, this is what we need. Probably the most important thing was to have actual young people whose lives had been affected come and testify. And that's a tricky thing too, because the whole point of this legislation is to not have people's pasts haunt them. And what we did was we found incredibly brave young people who were willing to come forward and say, I had a juvenile record, and although I'm basically outing myself on TV in perpetuity, I don't want this to happen to other people. I'm up here kind of taking one for the team on behalf of tens of thousands of other youth who shouldn't have to have their records follow them around. So it was a balancing act. And the thing that I think helped most was people saw this as an incredible issue about justice, that this was something that affected communities of color disproportionately, that affected poor people disproportionately, that was a key piece of why our prisons are filling up with people who were in foster care, with people who were homeless, because we are saddling them with these records. And it wasn't hard to get people to speak with passion. Our job was just to make sure that people were speaking with one voice.